Honorable Chair, respected speakers, ladies and gentlemen, Assalamu alaikum. I shall not go towards the history of Kashmir conflict and the recent situation in Indian occupied Kashmir, and I shall not discuss the political situation of Kashmir conflict. Being a student of law, I will take the opportunity to discuss some legal aspects of Kashmir conflict, and I am expecting the further clearance and way forward from respected speakers, especially Dr. Sajjad He is here, he is expert in international law, and he will guide about the future plan of action. Indian government was trying to suppress the peaceful, powerful, popular and legal movement for right to self-determination through draconian laws and military might, but couldn't succeed in her designs. On 5th August 2019, India adopted a new strategy to counter indigenous and widespread freedom struggle through constitutional invasion. The Indian Parliament de-operationalized the Article 370 of Indian Constitution. Here is a confusion. Some people say that they have abrogated the Article 370, but I think that 370 is there. They have de-operationalized that article from the Indian Constitution, and these constitutional amendments were set to be operative from 31st October 2019. The entire constitutional operation was carried out in utter violation of constitutional provisions of India. As a result of these unconstitutional, so-called constitutional amendments, the status of state of Jammu and Kashmir was reduced to mere union territory under the direct control of the central government of India. IUGIC, Indian occupied Jammu and Kashmir, was divided into two union territories, Jammu and Kashmir and Ladakh, administered by two lieutenant governors. As a direct consequence of these constitutional amendments, separate citizenship law under Article 35A of the Indian Constitution stands null and void. And that is the main implication of this constitutional amendment. Any Indian citizen from any part of the country can now buy property in Jammu and Kashmir, take a government job, and enjoy scholarship and other government benefits without any legal hindrances and restrictions. The Union Territory of Jammu and Kashmir will have its own elected assembly with a 5-year term, but that elected assembly they have no powers on legislation. They should have to got prior assent from the governor, lieutenant governor of Indian occupied Kashmir, even for the legislation. So that legislative assembly is not in true sense of the representation of the will of the people of Jammu and Kashmir. Ladakh will be under the direct administration of Indian government with its own lieutenant governor, but without any assembly. The Indian occupied Jammu and Kashmir no longer will have its own constitution, own flag, hence Indian occupied Jammu and Kashmir had lost, as Iftikhar Gilani has said, identity, status of the state, its own official flag, and separate constitution. The amendments in the Article 370 is also violation of the Constitution of India and also against the procedure of amendment provided in Article 370. Through Article 370, any subject matter or constitutional provision which was to be applied to the state had to be with the concurrence of the state government. And according to Article 370, Clause 2, the same concurrence had to be placed before the Constituent Assembly for its final decision. Under Article 370, Clause 3, the President could declare this article as inoperative or operative with notification and the prior recommendation of the Constituent Assembly of the state, a state being that Indian occupied Jammu and Kashmir. No recommendation under Article 370, Clause 3 was made by the Constituent Assembly because it was dissolved in 1957. After 1957, there was not any constituent assembly in Indian occupied Jammu and Kashmir. Even at this time, there is not any legislative assembly, any council of ministers. All these powers were constitutionally exercised by the Indian government. The presidential order of 2019 was passed with the concurrence of governor that has superseded the basic order of 1954, which was passed on the recommendation of the Constituent Assembly of Indian Occupied Jammu and Kashmir. It applied certain provisions of the Indian Constitution with modification and exceptions. The 2019 order made applicable all the provisions of the Indian Constitution on Indian Occupied Jammu and Kashmir. Through Article 367, the term Constituent Assembly appear in Article 370, Clause 3 has been changed to Legislative Assembly. Eminent Indian jurists such as A.G. Noorani termed the region of the special status of Kashmir is violation of Article 370 as it does not meet the dual modalities, namely concurrence by the government of the state and ratification by the Constituent Assembly. This is the systematic allowing out of Article 370 and the graver inroads into Kashmir's autonomy by violation of Article 370. The scrapping of Article 370 to change the status and demography of Indian occupied Jammu and Kashmir is blatant violation of United Nations resolutions, international human rights and humanitarian law, as well as the bilateral agreements between India and Pakistan. This act is also a violation of United Nations Security Council Resolution number 91 of 1951 and Resolution 122 of 1957. According to international humanitarian law, Kashmir conflict is international armed conflict, and Geneva Convention are applicable on this conflict. Article 49 of 4th Geneva Convention of 1949 provides the occupying power shall not import or transfer parts of its own civilian population into the territory it occupies. Indian action is violation of this article as well as Article 85, Clause 4A of the 1977 Additional Protocol 1 and Article 8, Clause 2B of the 1998 International Criminal Court Statute. India unilaterally changed the status of Jammu and Kashmir, which is the violation of Simla Agreement. And according to Article 60, Clause 1 of Vienna Convention of the Laws of Treaties, Vienna Convention on the Laws of Treaties 1969, Pakistan has the right to terminate the Simla Agreement or suspend its operation in whole or in part. Jammu and Kashmir is not a territorial part of India as it is disputed area, and the right to self-determination of the people of Jammu and Kashmir was agreed between India and Pakistan in United Nations Commission for India and Pakistan Resolution of 13th August 1948 and 5th January 1949. These two resolutions are like an agreement between the Pakistan and India. These are not just a resolution from Security Council. These are also the agreement, and Pakistan and India both has to follow this agreement. All 17 United Nations resolutions are acknowledging the right to self-determination of the people of Jammu and Kashmir. I will not go into the details of conventions, covenants, resolutions and decisions of the International Court of Justice about right to self-determination. The conclusion of all this is the right to self-determination has emerged as a jus cogens right, and that this right is superior to all other rights, and even a bilateral agreement between Pakistan and India cannot affect this right of the people of the state of Jammu and Kashmir. I shall sum up my talk with some suggestions for way forward. My first suggestion is, it is the right time for Pakistan to terminate Simla Agreement and other bilateral treaties about Jammu and Kashmir with India. Second, Azad Kashmir government and all parties Zuriyat Conference should lead the campaign of right to self-determination of the people of Jammu and Kashmir. And the third, the freedom struggle in Indian occupied Jammu and Kashmir should be recognized by the international community as national liberation movement against occupation of India. And this is not just a struggle of the people of Jammu and Kashmir that were the part of any territory or either Pakistan or India. Their freedom struggle is against the occupation of Indian forces, and that should be recognized by international community. And the fourth point, a legal campaign should be launched to expose India's human rights and humanitarian law violations and accountability under international law, because there is the procedure for accountability at national level and international level is available, and obligations of the states are defined in international conventions, covenants, and resolutions. So we should look for that. Once again, thank you very much for all of you coming here, and I think that we will listen from our foreign speakers, and especially Dr. Sayyid Muhammad Anwar about these legal approaches. Thank you very much.